Hello and welcome to our webinar topic on rent increases as we step you through the recent tenancy law changes and provide you with some examples on today's topic. My name is Lynn Smith and today I'm also joined by Cassie Chow. We're part of the education team at the RTA.
Thanks, Lynn. And hi, everybody. Great to be here today.
The RTA respectfully acknowledges the traditional owners and custodians on the land on which we meet today and where you are joining us as well, and pay our respects to elders past, present and emerging. The RTA's core function is to administer Queensland tenancy laws, and while we do not write the legislation, our role is to help parties understand their rights and obligations under the Residential Tenancies and Rooming Accommodation Act 2008. We're an independent statutory body and our services include our contact centre, our free dispute resolution service, and as the Queensland rental regulator for more than 30 years, we also undertake proactive and reactive monitoring and enforcement actions to uphold and enforce compliance with the rental laws. We hold and manage rental bonds, and we also provide education through various channels and work with our sector stakeholder groups. Let's have a look at the rental reform journey. It commenced with stage 1 as part of the Housing Legislation Amendment Act 2021. This was actually implemented in a staged approach during 2022 through to 2024. We also saw changes to rent increase frequency in July 2023. The Residential Tenancies and Rooming Accommodation and Other Legislation Amendment Act 2024 bill was introduced into Parliament in March. The bill then was passed and noted that during the parliamentary process, there were some minor changes made to the bill before it was passed. The bill is now the Act, which commenced on the 6th of June 2024. Some changes are in place now and started on assent on the 6th of June, while others will start on proclamation, and that date is yet to be advised. For today, we are just focusing on the rent increase legislation changes, which commenced on the 6th of June 2024. If we have a look at the legislation, before 1 July 23, the minimum period for rent increase frequency was 6 months. This was then changed to a 12-month frequency timeframe. From the 6th of June 2024, that 12-month timeframe is now attached to the rental premises, not the individual tenancies. We're going to be stepping you through some examples shortly to show you how this works. Before we keep going, we'll just have a look at what those amendments were that started on the 6th of June 2024. So again, the 12-month period is attached to the rental premises, not the individual tenancies, and that will continue to apply even if there's a change of managers or owners or tenants. There are exemptions to the 12-month minimum period before rent can be increased. The legislation outlines an exempt lessor or agent or provider, which includes public housing, and in most cases, community housing providers. To give you an example in the Act, it includes a lessor who receives funding under the Housing Act 2003 or under the Community Services Act 2007, or is a replacement lessor under a community housing provider tenancy agreement. The Act outlines the definition of an exempt lessor, so if you believe you or your organisation falls into this category, then please check the Act. If a tenant does feel the rent increase is excessive, there is a process that they can follow and details are available on the RTA's website. The written tenancy or rooming agreement must state the date of the last rent increase. As always, you are encouraged to ensure the latest version of the RTA forms are used. To give you an example of the rent increase, item 7 has been updated in asking the question on what date was the last rent increase. We also note that when lodging a bond with the RTA, our Form 2 bond lodgement form or through our RTA web services will ask you the same question for when the rent was last increased. The next part of the rent increase is that a tenant may request evidence of the day of the last rent increase, and the property manager or owner must provide this within 14 days of the request. Some of the examples provided in the Act include a copy of the previous tenancy agreement, written increase notice, or a rental ledger. Now, if providing any of these documents, you need to make sure you are removing or de-identifying any personal information about another person first. For this section, there is an exemption which refers to the previous lessor exemption. However, it does go one step further and also mentions that if the property has been purchased within the last 12 months and there is no evidence to provide, then an owner or a manager are exempt from providing the evidence. Again, in this particular section, there are penalty units that do apply. Now, a property manager or owner may apply to QCAT for permission to increase the rent within 12 months on the grounds of undue hardship. This would be up to the owner to provide their evidence and information as part of their application. It's also noted in this section that in deciding, the tribunal must have regard to any representation made by the tenant in relation to affordability of the premises and ability to continue to pay rent. So there is a two-part to this particular process. This section is being classified as a non-urgent application process, so an application will need to be made to the RTA's Free Dispute Resolution Service process first to get a notice of unresolved dispute before proceeding to QCAT. Now I'm going to hand over to Cassie. She's going to step you through some of the timelines and examples to demonstrate when rent increases can occur.
Thanks, Lynn. So let's go through this first example and timeline. Here we have a new 6-month tenancy starting on 10 May 2024 at an agreed rent of $450 per week. And this is an increase on the rent that was paid by the previous tenant. During the agreement on 6 June 2024, the new tenancy laws commence, which, as we know, attach the 12-month rent increase frequency to the property and applies even if there is a change of tenant or property owner or managing party. This means when the tenancy agreement ends and the tenant is offered a 6-month renewal agreement, the rent cannot be increased because it's not yet 12 months since the last rent increase or since the current rent amount became payable for the property. It therefore remains the same as the previous agreement at $450 per week. It's important to note here also that if the renewal had been signed prior to the legislation changes, but the start date of the agreement is after the changes commenced on 6 June 2024, then any rent increase written into the agreement is not valid. We would encourage parties who are in this situation to communicate with each other, remembering that early, open, and clear communication is often the key to resolving disputes. An option here might be for the property manager or owner to reissue an agreement that does comply with the rent increase frequency limit, and this would replace the previous agreement. Going back to our example on the screen though, after the renewal agreement ends on 11 February 2025, another renewal could be offered to the same tenant, or an agreement could be commenced with a new tenant starting a new tenancy on 12 February 2025, and the rent can now be increased because it is at least 12 months since the last rent increase. In our second example here, we have a tenancy which started in early 2024. The tenancy begins on 10 February 2024, and the agreement ends on 10 August 2024. The agreed rental amount is $450 per week, and this is a higher rent amount than the previous tenant was paying. We've noted here again the commencement of the new laws for rent increases on 6th of June 2024, and this means when the tenant commences a renewal of their agreement for 12 months on 11 August 2024, the rent cannot be increased because it's not yet been 12 months after the last rent increase or since the current rent amount became payable for the property. The managing party chooses to include a special term in the agreement, which states there will be an increase in rent up to $480 per week on 10 February 2025. This then complies with the minimum 12 months between rent increases. Following the legislative process, they also issue a notice of rent increase after the agreement commences and with at least 2 months' notice, so on or before 10 December 2024. This reminds the tenant that the rent will increase up to $480 per week on 10 February 2025. At the end of the renewal agreement, the managing party offers another renewal to the tenant for 6 months at $480 per week to align the end of the second renewal with the original last rent increase date. So in our final example, we're exploring what the timeline for a lease break might look like. We do know that lease breaks happen and can appreciate that some of you might be wondering how to navigate them after the changes to the rent increase legislation. On this timeline, we have a 6-month tenancy commencing on 10 May 2024 and ending on 10 November 2024. As per the previous examples, the agreed rental amount is $450 per week, and this is an increase on the amount of rent the previous tenant was paying. We can see on the screen that the tenant in this example breaks lease and ends their agreement on 20 August 2024. They then pay rent until a new tenant is found, and the 12-month tenancy starts on 30 August 2024. The rent can't be increased at the start of the new tenant's agreement because it's not yet 12 months after the last rent increase or since the last rent amount became payable. However, the managing party chooses to include a special term for a rent increase on 10 May 2025, which would then be 12 months after the last rent increase. They follow the legislated process and specify in the written agreement that there will be a rent increase in the middle of the agreement and how it will be calculated or how much the new rent will be, which in this case is $470 per week. The legislation also requires the managing party to issue a separate notice of the rent increase after the tenancy commences and at least 2 months prior to the date of the increase. So they do this on 10 March 2025. After the agreement ends, the managing party offers the tenant a 12-month renewal, noting that the rent remains at $470 per week until it can be increased again on 10 May 2026.
Thanks, Cassie. Look, we know it's a lot to take in and we appreciate your time today. We do have resources to help you navigate these changes, including frequently asked questions on our website. The RTA does provide a lot of information through various channels, not just our website, but through our YouTube videos, podcasts, or you can sign up for our e-news or follow us on LinkedIn. Our friendly contact centre staff can also assist you with your tenancy or bond inquiries Monday to Friday on 1300 366 311. Thank you, Cassie, for joining me today.
Thanks, Lynn, for having me here today. And thank you, everybody, for being here.
Great. Thanks, everyone, for watching us. And we hope to see you at one of our upcoming webinars or in person at one of our information sessions across Queensland. Details of our events can be found on the RTA's website at rta.qld.gov.au/events. Thanks again for joining us. We look forward to seeing you soon. The webinar will now end.